I'm going to go ahead and officially kick us off. So welcome everybody. My name is Matthew Rappaport. I'm Vice Managing Partner, and I am the co-chair of the Taxation Group here at Falcon, Rappaport and Berkman LLP. We're an LLP now. For those of you who have known us for a while, ever since our 2018 founding, we were founded as a PLLC. And then on the occasion of going ahead and merging with Mr. Verdon, who is one of the panelists today, and his practice in Newport Beach, California, we came to find out that PLLCs can't practice in California. So we converted entities to an LLP, and that's what we are now. We are Falcon, Rappaport, and Berkman LLP. And we are now, thanks to Mr. Verdon joining the firm and expanding its capabilities in ways that you will find out about today, we are now bi-coastal. So in addition to having offices, the Nerve Center is on Long Island. Then we have the Manhattan office, we have Boca Raton, Florida, and there is Newport Beach, California. Which that's the most she office, right, Jeff? That's the Newport Beach, California is the most high-end office. Super nice out there. So any excuse that all of us can get to go out there, we pretty much take. But Jeff practices out of Newport Beach, even though he's physically on Long Island today. Jeff is visiting the East Coast, but his operations are out of Newport Beach, and the Asset Protection Department's Nerve Center is in Newport Beach, and we are really, really excited, not only for the geography and the gorgeousness of Southern California, but also for the idea that, as Jeff will tell you when he formally introduces himself in a couple of moments, Jeff practices in the areas of asset protection and high net worth and ultra high net worth estate planning. And that is an excellent capability that look, we did asset protection work out of the New York office prior to combining with Jeff's firm, but this is a completely different dimension. What you're going to hear about today is how the asset protection practice in our firm has been just supercharged and expanded and given way more technical capability now that we have Jeff and his colleagues as formally part of the firm. So that's your topic for today. But the other thing that you should be aware of is that on January 1st, so on December 1st of 2022, Jeff and his practice formally became part of ours. On January 1st of 2023, we became official with Weltman and Moskowitz, which was at the time of its existence a creditors' rights boutique and doing all sorts of things related to the representation of folks that were on the, I don't know, is it fair, Michael and Richard, to say like on offense in bankruptcy and creditor proceedings, right? That's where you gentlemen have your expertise. And just as it happens, these two things were not even done as strategically intertwining transactions, even though that's the way it turned out. As these two things were being solidified in parallel, Ken Falcon, the managing partner, and myself turned to each other and said, you know what's really cool about this? Now we have both angles of folks who are trying to analyze their situation in terms of what kind of vulnerabilities do I have in my own personal financial situation and legal situation? What kind of forecast can I make about any ongoing situations where asset protection is a lot harder, right? We're going to get into timing today, but asset protection is a lot harder when you are doing it when the quote unquote storm clouds are gathering or when you have a full-blown claim against you or even a full-blown judgment. But in those cases, it's very useful to have Michael and Richard here because they and their team are the creditors' rights team, and they look at things all the time from the opposite angle that Jeff and I are normally looking at things from. Jeff and I are looking at things from, hey, how do we go ahead and build the fortress to make sure that it is as hard as possible for people to get at assets? And Michael and Richard, on the other hand, are spending all of their time on behalf of creditors trying to get at assets. So this, having both angles under the same roof, is an enormous advantage that we feel is one of the many reasons why our asset protection practice is different in very good ways from the ones that are out there, because we know that all of you folks have choices. But in terms of one of the ways that we feel we're different is that we are now covering both angles on the same roof, which is a huge, huge advantage. So that's what today's presentation is all about. A standard disclaimer, right? What kind of lawyers would we be if we didn't have disclaimers? Not tax or legal advice today. Everything today is for general information and educational purposes. Nothing about this program creates an attorney-client relationship, even though I'm happy to say, looking at the attendee list, we do have attorney-client relationships with several of you. However, today is not part of the actual engagements that you may have with us, and viewing the program today or on recording does not create an attorney-client relationship. So if you want to learn about me, we have the ability to send out all of the slides, but I have already spoken way too much for my allotment today. I'm not going to be a featured person in this program. Instead, you will meet the gentlemen who are the proud new members of Falcon, Rappaport, and Berkman LLP, and I will begin with Mr. Verdon. Jeff, it's so much better that I have moved to Jeff's slide. Jeff is better looking and also has so much deeper expertise in asset protection. So Jeff, why don't you take it from here and further introduce yourself and tell everybody what specifically your practice is all about.
Thank you, Matt, and Michael and Richard. Great to be with you. Thank you all for joining the workshop this afternoon. I know you have busy schedules, and we're very honored that you took a few moments out of your day to join us. So my background, I started my career as a tax lawyer after getting my LLM at my alma mater, Boston University. I entered the workforce in Southern California and started doing estate planning. About 5 or 6 years into my practice, a small group of doctors came in to see me to do their estate planning. And they wanted to retire in 5 years, but their office manager told them they couldn't get tail insurance to cover them for their malpractice liability 5 years post-retirement. So when these doctors hung up their stethoscopes and stopped delivering babies, they were going to be on the hook for that child's malpractice liability, until the kid reached the age of 18, plus the statute of limitations back in those days. This was in the mid-'80s. And they were going to be bare, and this was just unacceptable. And I was tasked as a young lawyer with coming up with a way to protect their assets in case they got sued when they had no insurance. And of course, this isn't something we learned in law school or graduate tax program. As estate planning lawyers, our task was to pass wealth on to the next generation with the least amount of taxes and administrative inconveniences, but never even consider the fact that our clients might be sued and lose everything that they had, or most of what they had, and there may not be an estate to retire on or one to pass on to their loved ones. So after putting together what by today's standard was a very basic asset protection plan, using what was very popular in those days, the family limited partnership and the charging order protections, I retooled the way that I approached estate planning, because it became obvious to me that my more important role in representing my client was not to make their kids and grandkids richer, which is what we do as estate planners, but rather to protect our clients in case the what if were to happen. And so I began to practice or include the concept of integration of estate planning with asset protection planning. And as I say, this happened back in the mid-'80s. And I must say, fast forward 30 some years later, I don't think the estate planning profession has really adopted, and it's not ubiquitous to see asset protection planning being discussed amongst the estate planning bar. So I hope what you take away from today's discussion is asset protection planning is nothing to be afraid of. You have to make sure you do the proper, fraudulent transfer analysis, but the benefits of having asset protection built into the estate planning are enormously important for your clients. And hopefully this will allow you to expand your practice as well.
Fantastic. Thanks, Jeff. And next up, we have Mr. Weltman.
Yes, hello, everybody. I'm really happy to be here at Falcon, Rappaport, and Berkman, really to talk about the creditors' rights aspects of some of the asset protection planning, and we're going to get into this as we go along. But primarily, what I look at is vulnerability. The word was mentioned before. We have clients who necessarily do not want to file bankruptcy, but need to look at what their options are under the bankruptcy laws and what their vulnerability is to a challenge if there was an involuntary bankruptcy filed, for example, and they had to face a trustee, or if they have a lien or a judgment creditor, including the IRS or other creditors, how vulnerable are their assets, even under non-bankruptcy law, such as New York law, New Jersey, a substantive law. What can the creditors get from those assets? And if there was an asset protection structure, can the asset protection structure be broken? So those are the kind of things that that I look at. I have been a long time bankruptcy attorney, creditors' rights attorney, and help a lot of folks to protect their wealth, protect their assets, and on the creditor side, to be able to collect and enforce their judgments and claims against the debtors. One comment I will make, and everybody should be aware of this: if there is no impediment to collection lawyers go after the low-hanging fruit, which is going to be bank accounts, going to be wages, going to be going to be accounts receivable, or other kinds of assets before they really go to real estate. So we can talk about all of this, and we can talk about how assets are not protected and typically can be liened, can be seized without an asset protection structure or advanced estate plan.
Excellent. And finally, as far as panelists go, Mr. Moskowitz, if you will.
Yes, thank you, Matt, and thank you for having us today. And I welcome all the participants. I hope it will be a fruitful webinar, and there will be a few nuggets that you can take away from this. My background is originally clerking for a bankruptcy judge way back in law school back in 1980. And I've been in the bankruptcy field for over 40 years. And we've morphed. Richard and I were together as a partnership for 35 years, originally representing debtors, and we morphed into a creditors' rights firm. We represent many of the largest credit unions in the United States. When their members file bankruptcy, we represent local, regional, national banks. So we come across these issues oftentimes, but I'm going to speak today from the debtor's perspective. And it is very difficult oftentimes to protect your assets if you haven't planned. So the key takeaway today is early planning and proper planning with the right attorneys who know what they're doing to protect your assets. And I think that's going to lead into what Jeff is going to start us off with.
Excellent. That's a great segue. Before I turn it over to Jeff to start us off with basics, I just want to tell everybody, if you want to use the Q&A function on Zoom to send in questions for the panel's consideration, do always feel free, because we want to leave space toward the last 5, maybe 10 minutes to address people's questions. And if they're appropriate, I may, as moderator, go ahead and call out some questions that come in so we can address them in line. So do feel free to use the Q&A function to chime in whenever you feel the need. And if you want to ask questions that are even related, not necessarily touch directly on what the slide content is and the discussion is, that's okay too, because we want this to be informative for everybody. So with that, let me turn it back over to Jeff. Jeff, kindly take us through for a moment, right? We try to keep the slides basic to make sure that the conversation can be engaging and you're not going ahead distracted by too much text. But Jeff, take us into for a moment, like the fundamentals behind what asset protection is really about. Because I think, Jeff, you would agree, there's a lot of misconceptions out there among even professionals regarding what it is and what it's supposed to accomplish.
Thank you, Matt. When I started to practice in this area, it wasn't called asset protection, it was called free litigation planning. So we've come a long way. Asset protection planning is simply rearranging title to one's assets, selected assets, not all their assets, so as to place them beyond the reach of a future unknown, unforeseeable lawsuit creditor or creditor. What asset protection is not, at least the way that we practice it before I joined the firm and how we practice it now, it is not about defrauding creditors. It's not about helping people beat their legitimate obligations. It's really about leveling the playing field. So if you are faced with a future lawsuit, you have an opportunity to protect yourself. Corporations were invented because businesses wanted to protect themselves against the individuals against business liability. Excuse me. And so asset protection planning is essentially an extension of that concept. We integrate it with estate planning. I'm not a proponent of standalone asset protection planning. There are some very good lawyers around the country, good friends of mine, that only do asset protection planning, do not integrate it with estate planning. But I was classically trained as an estate and tax lawyer. And so I feel it's important to integrate both estate planning with asset protection, because if ultimately under the hot lights and rubber hoses, you're asked, why did you set up your asset protection plan? You want to have a business reason why you did it. And estate planning and business planning are two very good reasons for that. Next slide.
Excellent. Okay, and now we get into the why. So I think, Jeff, if you want to expand here, there's sort of, we went over the what and what you're accomplishing there, but then there's the why. So tell us for a moment about the why.
Well, it's really why not? Say you go to see your estate planning lawyer and he does your living trust, your wills, your durable powers of attorney, and healthcare directives. You walk out the door with your binder, you're driving down the street, you're texting your family about how wonderful the experience was, and boom, you run into a trial lawyer at a crosswalk, and now you're going to be sued for $50 million. When you come to learn that revocable living trust that you set up is not going to protect you against lawsuits, and you don't have anything more than a $100,000 liability policy on your automobile, you're in serious trouble. So, Richard, when you deal with creditors all the time, have you ever seen a living trust, a family living trust that's ever protected a single asset?
No, Jeff, that's a great question, and it's a very, very common fallacy. People think that this revocable trust or a self-settled trust, or sometimes they go to one of the 19 states that have a domestic asset protection trust, but they have no connection with that state, no connection with, they have no assets in that state. So typically those trusts are really, they're very helpful for passing wealth, but they're not helpful for protecting that wealth from creditors.
And yet the majority of trusts that estate planners do involve a family of trust, a revocable family trust, which are not going to provide those sorts of protection. And I frankly feel if somebody were to go through a lawsuit and lose their wealth, who had a family trust done, and the lawyer who did the trust did not at least tell them that there were other options they could use to protect their assets, that client's going to not be very happy with that law firm and may decide to to take further action. Next slide, Matt. Lawsuits have surpassed baseball as the national pastime. There's a new euphemism, a new word in a lexicon called LawFare. And LawFare now is being used to get people to change their behavior where they otherwise may not be able to do so under negotiations and settlements. 95% of the world's lawsuits are filed in the US. And that is probably likely because of the contingency fee system we have in this country. We're only one of two countries in the world that allow a lawyer to take a stake in the outcome of clients' cases, and that gives people more access to the court system. In 2020 alone, there were over 15 million lawsuits that were filed in the US. So could you be next? Quite possible. And if you live in states like California or New York, Florida, those are the three most litigious states in the country.
And I will just add to that, Jeff, that there was a period of time where people became a little bit complacent, during the periods of uncertainty and during the moratorium related to the pandemic. There really weren't that many lawsuits. A lot of collection attorneys were not really pursuing litigation. The courts were closed. That's, the last 3 years, but things were changing. And I think people really need to pay attention right now.
The other thing I do want to throw in there, by the way, is a couple of things. One of them is what a lot of non-litigators are unaware of in New York is that when the pandemic occurred, Governor Cuomo had a tolling of the statutes of limitations associated with various civil actions. And there was insurance litigation over whether or not the statute of limitations extension was a suspension or a tolling. So in suspension, right, if Governor Cuomo said we're going to move it out approximately 8 months. So the question was, did it just mean that if the statute of limitations expired during the suspension, then it would be carried to the end of the suspension? Or did it mean that every statute of limitations that was running during that period would get an 8-month extension tacked onto it? And the answer was actually the latter. So as it happens, if a statute of limitations was running during COVID, then, or if it began in the middle of COVID, there is an extension to that statute of limitations for a lot of things that it still runs today. The pandemic emergency was declared 3 years ago this month. And for a 3-year statute of limitations, if that statute had begun in October, in March of 2020, it runs out approximately November of 2023 if it's a 3-year statute of limitations. So what a lot of people don't realize is when it comes to the pandemic, a lot of, in New York at least, those statutes of limitations are actually extended. There have been court decisions around the idea that the statute of limitations decisions from Governor Cuomo were actually extensions of the statute, not mere suspensions of them. So this brings up, Richard, when you talked about the idea that the pandemic, a lot of people saw it as a free pass. I'm aware of a couple of cases in which folks have skipped out on their obligations and believe that they're not going to get sued. And the answer is you can still get sued with an extended statute of limitations. And if your assets are not protected, then the creditors can still come after you. So it's a good point you bring up that the pandemic is not just people just getting a free pass on stuff. So I think that's an important point.
Michael, does that extend to the 4-year statute of limitations to bring a fraudulent transfer claim or whatever the particular jurisdiction provides?
It's perhaps Richard and Michael can comment further, but my understanding of it is that any statute of limitations that's under the civil practice law and rules, the CPLR, has been extended by, if it fell during the 2020 pandemic period between March and November of 2020, those 8 months effectively don't count and they get tacked onto what would normally be the end of that statute. So if the 4-year statute is under the CPLR, I believe it would apply, but I don't know, Michael and Richard, if you have commentary on that.
Well, I would just say that the 4-year statute is not under the CPLR. There's a fraud reach back in New York that is different than that. It could be as much as 6 years, and I have not seen any cases saying that statute of limitations is extended. But certainly the CPLR is a different animal, and various states have treated their collection statutes differently. And this really underscores what Jeff was saying in the beginning, and that is you need an expert. You need an expert both on the collection side to look at vulnerability and also on the asset protection side to really figure out what your dates are. I mean, this is not a do-it-yourself project, and I think that is one of the nuggets that you're going to get from the presentation today.
So what you see, thank you, Richard. What you see on the slide is an affidavit of solvency. And for those of you that practice in the estate area, even if you're involved in transactions, it's always important to make sure that when you do a transfer, a gratuitous transfer to an irrevocable trust or wherever the asset is going, that the client is solvent after the transfer. Under the recent changes to the fraudulent transfer rules, namely the Voidable Transactions Act, the individual has to remain solvent after the transfers. And even if you're doing it for estate planning purposes, if the transfer renders you insolvent because you made a gift because you wanted to take advantage of your generous unified credit, that transfer can be attacked as a fraudulent transfer within the statutory period because it rendered you insolvent. Using the affidavit of solvency, and I'm happy to provide a copy of the one that we use, is always a good thing to have in your file to make sure that you went through the drill and you made sure the client was solvent after the transfers. Matt? So folks, it's not about what you do, it's about what you own. And let me make my point this way. Let's say you're walking down the street and a homeless person comes up and asks you for $20 and you don't want to give it to him, and the person accosts you and knocks you down and injures your property, or injures you and damages your property. And you call up your local Jacoby and Myers office and you want to sue that son of a gun for injuring and even damaging your property. As soon as a lawyer on the other side realizes that the person that they'd be suing has no assets, it's going to be very difficult for you to find a lawyer. So it's important that you understand what the genesis of lawsuits. It's driven by economics today. It's not driven by philosophy or a cause. So the more that we can remove the profit from the pursuit, the more opportunities you're going to have to get yourself out of a lawsuit quick and cheap. And that's how we approach asset protection. Next slide, Matt.
I was going to add one more thing on this. What I often tell people in terms of litigating as a matter of course is that, especially if it's ever your first time litigating, I'm not personally a litigator, I'm a deal lawyer, and there's a reason why I'm a deal lawyer. But at the same time, I always tell anybody who's considering litigation or getting involved in litigation that it is the worst thing that can happen to you that does not involve death or permanent disability. It's the worst thing that can happen to you. Any type of litigation, divorce litigation, child custody litigation, civil litigation, criminal litigation, anything. it's terrible. So all parties in general, when it comes to litigation, should be motivated to end the litigation. But I think what Jeff is going to illustrate to you is that there are ends to litigation that are more or less costly depending on how much planning you've done in order to insulate yourself when you're on the defense side. When you're on the plaintiff side, right, and this goes into, Jeff is going to explain these 2 points on this slide. But as to the first one, which is doubt as to liability, I have a close relative who is a litigator at an AmLaw 100 firm. And effectively, when it comes to doubt as to liability, there is almost always doubt as to liability. The fact of the matter is that if a lawsuit survives a motion to dismiss, there's always a chance that even the faintest claim could win, and there's always a chance that the strongest defense could lose. So usually the motion to dismiss is the first line of defense if somebody thinks that a lawsuit really doesn't have any merit. And if there's a survival of a motion to dismiss, the overwhelming amount of the time, the lawsuit ends in settlement. So what Jeff's going to talk about is that when you're negotiating settlement, there is more or less leverage depending on how much planning's in place as far as whether or not people can reach certain assets, even if they do notch a judgment or you do reach a settlement agreement. So Jeff, go into this for a second and give us the skinny on these 2 different points, because it's really important in terms of what happens when you find yourself in one of these situations.
Well, and I'll illustrate that point with actual cases, but the 15 million lawsuits I mentioned earlier that were filed in 2020, 90% or more of those lawsuits settle. They settle for one of 2 reasons: doubt as to liability or doubt as to collectability. And you might say we're in the doubt as to collectability business. Again, we don't defraud creditors. We don't help our clients get out of legal obligations that they might have. But our job as wealth planners, as estate planners, is to pass that legacy on to the next generation. And we want to do that without the interference of lawsuits. So doubt as to collectability is a very significant reason why cases settle. Next slide, Matt.
Before you depart from it, I just want to cue Michael in for 1 second. Michael, can you sort of describe on the debtor side what it's like advising clients in settlement negotiations when there's loss of assets versus somebody who's closer to what they call in colloquial parlance judgment proof, right? Like, I think it'd be enlightening to just get some perspective in terms of, what is it like when the assets are easy to reach versus the assets are non-existent or the assets are hard to reach? Like, what's it like from your perspective in terms of speaking with the debtor, and what types of things you do both in facing negotiations toward the other side and advising the debtor privately?
Well, Matt, I think that the best bankruptcy case I could ever file is the one that I don't file. And the way you don't file is by being properly prepared. The problem is that many debtors do not plan or prepare, and they end up coming to us at the last minute. So I think you mentioned 3 different situations. You mentioned a debtor with no assets. A debtor with no assets is a very simple case. A debtor with minimal assets can probably exempt them under the bankruptcy exemptions. Now, when you file a personal bankruptcy petition, you get to choose between the state or the federal exemptions. Each state has different exemptions, and some states are very generous, such as Florida, which has a full homestead exemption, but other states are not as generous. So as a debtor's attorney, you have to figure out which are the appropriate exemptions to use to protect as many of the assets as possible. But going back to my first point about not filing a bankruptcy is leverage, just the way Jeff is going to speak about leverage in the next slide or 2, when you have a foreign asset protection trust. Bankruptcy is the same thing. When you have a client coming to you that may have some exposure, you want to use bankruptcy as both a sword and a shield. A sword to use as leverage by threatening the potential bankruptcy, and the shield is really the bankruptcy itself. So oftentimes when we have cases where they may not be able to protect all of their assets, we will attempt to negotiate a settlement with the creditor with the threat of bankruptcy. I think, however, the threat of bankruptcy is not as potent as the foreign asset trust that Jeff is going to talk about, and I'd rather let him talk about that first.
That takes us nicely into the next slide. Thank you, Michael. So Jeff, does asset protection really work?
Matt, it depends how you define the word work. In my world, in our world, work means that you're better off having put the plans in place and the structures in place to achieve a potential lower and cheaper and quicker settlement than not having done it at all. And as the
Shall we see some numbers?
yes, we shall.
Yeah, this is, I think,
Thank
pretty
you.
illustrative.
So here's a series of examples of clients of ours who have actually employed asset protection planning strategies before there was a claim and what the results were when they eventually ultimately settled. As you mentioned, you made a very smart point before, Matt, about litigation being an awful experience. It's just as bad for the plaintiff as it is for the defendant. It's an awful experience to go through. So the quicker and cheaper we can get you out of that lawsuit, having employed these strategies, the better your life is going to be. And so I won't go through all these cases. There's some fascinating facts, but we're going to run out of time. But you can see this on our website. But I think by anybody's metric, the definition of whether asset protection planning worked when you could settle a $58 million claim for $7 million and so forth and so on. I think without these structures being in place, these results could not have been achieved.
There's a worthy digression to have here, as much as I know we're time limited. I think in terms of, I've spotted a couple of our real estate clients who are on the program today, and I'm sure we're going to have real estate folks who are on the program when they're watching on recording. There's a key question when you look at this different list of stuff here. You've got three things here that are related to loans. You've got a bank loan, a personal loan, and a personal guarantee. The question I have for Michael and Richard is, when you submit in connection with a personal guarantee or in connection with creditworthiness when it comes to securing a loan, my understanding has always been that when you submit a personal financial statement or a financial statement for your business that includes certain assets, it is functionally impossible after submitting those assets as part of a creditworthiness analysis and underwriting to shield those assets from those particular lender creditors. Now, you may be able to use planning that Jeff might put into place to shield from different creditors, but my understanding has always been that when you submit to a lender that your personal balance sheet or your business's balance sheet includes certain assets, you cannot then alienate those assets and claim that they're exempt from the particular creditor who underwrote you using that asset. Does that sound correct to you?
From a creditor's perspective, that's absolutely correct. It's called reasonable reliance. And that reasonable reliance extends to bankruptcy. So if you give a personal financial statement to a creditor and you lied and seriously materially misrepresented your financial situation, it can be exempted in bankruptcy. When I say exempted, it could be eliminated from the bankruptcy protection through an adversary proceeding.
Matt, I think just to follow up on that, I think Richard, I think what Matt's talking about is whether or not you create a trust, whether it's domestic or foreign, after you provided the personal financial statement to the bank. And I think the answer, unfortunately, as a lawyer's answer, is it depends. It depends what happened to those assets. Was it proper estate planning? Was it with the advice of counsel for estate planning and not with the actual intent to delay, hinder, or defraud creditors? So it's obviously a factual determination later on, and I wouldn't give you a black or white answer on that. I would say it depends.
Yeah, and timing is everything, and it really depends upon what motivated the estate planning, and there are a lot of facts and issues. Michael is exactly right, but to Matt's point, certainly there are questions that are raised and will be raised if the assets are on the personal financial statement and are relied upon by that particular creditor.
And just one more thing, Matt. Also, this is our pre-discovery for litigation, because the PFS, or the personal financial statement, is used to determine where the assets are located, and then we can figure out what happened to them later on if they're no longer there.
Very useful information. So I'm glad at least I brought that question up because I'm sure it's relevant to a couple people here. Back to Mr. Verdon. So tell us, Jeff, in terms of, this is a really cool schematic that you've put together in terms of people wondering like, hey, can this happen to me? Like, what's the likelihood of this happening to me? And I think you've put together this very cool worksheet that basically answers the question, hey, how likely is it that this stuff can happen to you?
And for those that would like to get a copy of this lawsuit exposure test, you can go to our website and download the Word version. You can put your letterhead on it and sit down and get and administer it to your clients. But a lot of people you sit down with, particularly during the estate planning process, aren't even thinking about lawsuit protection. And this helps them, laser focus on just how exposed they are. And if they answer on the higher end of the answer key, Matt, they're likely going to be more likely to be sued than somebody who doesn't. So feel free to use this or some other medium to be able to focus a client's attention on their exposure.
Fantastic. And now we get to this asset protection trust fork in the road. Jeff, navigate us through this.
Thank you, Matt. So when I started doing asset protection planning, I was using strictly domestic strategies. This was in 85, 86. And what I found was that while a family limited partnership on the charging order, which we'll get to in a few minutes, would protect assets inside the partnership, if you lost a lawsuit and there was a judgment against you, you couldn't access those distributions from the partnership, because if you did, you'd have to turn them over to the creditor. So really what you were looking for was not asset protection. Our clients were looking for lifestyle protection. And there's a big difference between the two. And a family limited partnership and the charging order protection would not provide that, because if you couldn't distribute assets out to the member, to the partner, or the member when LLCs were eventually ubiquitous, it really wasn't a very effective plan. So we looked for something else, and that something else was a foreign asset protection trust. And I give all the credit to my late and good friend Barry Engel, who came up with the structure of setting up a foreign trust in an asset protection trust jurisdiction, putting assets into an LLC or a limited partnership. Back in those days, we only had limited partnerships, and then having the partnership interest owned by the trust. So if there was a lawsuit against the settlor of the trust, the assets inside the partnership, which was owned by the trust, would not be susceptible to a creditor seeking to attach those assets. The assets in the limited partnership could then be dropped into the trust, and the trustee could pay to or for the benefit of the named beneficiaries. And this was a much more effective strategy in forms of asset protection, particularly in trying to get a creditor to settle with you, because when they realized the efforts they would have to go to try to penetrate that trust, it just didn't make economic sense. In 1997, Alaska adopted the first domestic asset protection trust law. And then that was followed by Nevada and South Dakota. And now there is, I believe it was Matt that mentioned, there's 19, or maybe it was Richard, 19 states now that have some form or another of self-settled spendthrift trust litigation or legislation, rather, i.e. asset protection trust laws. So in deciding whether you use a domestic asset protection trust or a foreign asset protection trust, it really depends upon how much certainty you want on the results if there is a subsequent creditor claim. If you never have a creditor claim, it doesn't become relevant. From my experience, we don't have enough law that's developed in this country to determine really how effective a domestic asset protection trust will be versus a foreign asset protection trust. With the foreign asset protection trust, we know a few things. We know the foreign jurisdiction has no comity, C-O-M-I-T-Y. They do not recognize judgments coming out of another country or another state, including bankruptcy judgments. With a domestic trust, you have this concept called federalism. I'll take you back to your 12th grade government class, where you learned that whatever powers aren't reserved by the feds are delegated to the states. Well, there are certain federal claims that can arise against you, even if you live in one of those domestic asset protection trust jurisdictions, where the asset protection trust will not protect you. One of those happens to be a bankruptcy, which is what Richard and Michael's, that's their area of expertise. If you set up a domestic asset protection trust and you transfer assets to that trust and you file bankruptcy or you're put into a bankruptcy involuntarily, that bankruptcy trustee has up to 10 years to challenge the transfer to a self-settled trust or other similar device. So when I'm sitting with a client and they want asset protection, and I give them a choice between a foreign asset protection trust and a domestic asset protection trust, I cannot give them the certainty that with a domestic asset protection trust, especially if they're involved in a bankruptcy situation, which can happen, versus a foreign trust where even a bankruptcy judgment creditor has no ability to enforce that judgment against the trust. And there is a number of other reasons why I favor a foreign trust over a domestic trust. Now, there are other lawyers around the country that do domestic asset protection trust. My good friend Steve Oceans, who's a terrific lawyer and estate planner and asset protection expert, he lives in Nevada and he recommends domestic asset protection trust because that's what Nevada's laws say. If you live in a domestic asset protection trust state and you set up an asset protection state, but for violating one of these federal rules like the bankruptcy law I just mentioned, the likelihood is that domestic trust is going to work fine for you in terms of preventing a creditor from breaking through the trust. But if you live in a state like California or New York and you set up a South Dakota or a Nevada asset protection trust, we don't really know yet whether under choice of law rules that domestic asset protection trust is going to protect you. So if you have enough assets, enough liquid assets to matter, and foreign asset protection trusts are pretty much reserved just for liquid assets, not real estate and immovable assets. If you have enough assets to matter and you can afford the foreign asset protection trust, that's the device you want to go with. The IRS would not print all the forms that people would have to complete describing and disclosing their foreign transactions if going offshore were illegal. It's perfectly legal to go offshore. You just have to tell the IRS what you're doing and they leave you alone. And I can say, after having set up foreign trusts since 1989, which is when I did my first one with Barry Engel, that we have never had a client who was audited because they had a foreign trust. Why? Because they have to tell the IRS they have a foreign trust and disclose all the issues about those foreign trusts, and all the income deduction credit losses generated within that foreign trust fall to the taxpayer's 1040. So it's very transparent, and therefore the IRS doesn't care that you have one.
Jeff, could I just clarify one point for our audience?
Please.
With respect to the look-back period for a trustee in bankruptcy seeking to set aside one of these trusts, whether it be domestic or foreign, they have the right to look back 10 years from the time of the filing of the petition to invalidate the transfer, but they only have 2 years to do it from the time the bankruptcy petition is filed. They have 2 years to file an adversarial proceeding to try and set it aside. But the look-back period is 10 years from the transfer, and that was based upon an amendment to the bankruptcy code back in 2005 to try and limit wealth preservation strategies, which historically the bankruptcy court has not looked kindly upon.
That's why you want to stay out of bankruptcy, and having an asset protection plan will give you the ability to do that. And there's something else I should mention. When you have an asset protection plan in place, and then you're dealing with a lawsuit, you're going to have a much stronger constitution, a much stronger backbone to push back against these frivolous lawsuits, because you're not as concerned that if you lose the lawsuit, you're going to get wiped out financially. And so there's a lot of both psychological as well as legal reasons having an asset protection plan in place before the claim happens, before your hair catches on fire, is obviously more preferable.
One other thing about domestic asset protection trusts, I'm going to preempt the question. I see Edward asked a question, by the way, that we can quickly answer. Is the taxation of each one the same, foreign and domestic asset protection trust? Jeff, I believe the answer would be yes, right? That both of these are grantor trusts and they show up on the grantor's Form 1040, and until the grantor dies, there's not really any sort of income tax or implication to them. But I would also add, number one, for those of you in New York who are wondering what domestic asset protection trust jurisdiction is physically closest to New York, that is now Connecticut as of January 1st of 2020, I do believe. So Connecticut is a DAP state, and that's the closest one you have to New York, but there's also Delaware and there's also Rhode Island. Then second, even though Jeff has highlighted that there are different jurisdictions, and you have Mr. Oceans is in Nevada, there are different laws in different jurisdictions that may make a difference depending on what you're looking for. So for instance, Nevada in my mind has the Wild West element to it, where it says, Jeff, correct me if I'm wrong, a Nevada asset protection trust also allows protection from the claims of family creditors, ex-spouses, even children. They allow you, as long as there is no fraudulent transfer under its own Voidable Transactions Act and things like that, they allow you to protect against all manner of stuff under their law. That is not the case, to my knowledge, in Connecticut. They don't quite put protections that strong on it. So you really do have to investigate in each jurisdiction. The laws are not exactly the same. I don't know, Jeff, if you have any further comment than that, but I think that's an
What you're
important thing we
referring
gotta
to is
understand.
what's called exception creditors. And you're right. Many of the 19 states that have adopted this legislation could only get them passed if the legislature had carved out certain exception creditors. Delaware, which is another popular state, it would not be a state I would normally set up an asset protection trust in because they have exception creditors. And there's a very famous case called Kloiber, which allowed the divorcing spouse of a child of the settlor to invade the trust as part of the settlement of their divorce. So it didn't quite turn out the way it was supposed to. So you want to use a state where there are no exception creditors, and Nevada and South Dakota both have state Supreme Court case law upholding the efficacy of the asset protection trust in the case of a child support or alimony.
All right, so let's get into, Jeff, rental real estate. So I think you use outside versus inside, as I always used upstream versus downstream, but this really are two different terms with the same concept. Take us through, Jeff, for a moment, what the differences are between the two.
Thank you, Matt. So if you have a business and the business is operating, and most businesses, they have rolling stock, retained earnings, IP, machinery, equipment. You send your secretary out to pick up lunch and she gets into an accident on the way back and injures or kills somebody, and you don't have enough liability insurance. All the assets inside the company are vulnerable. You have real estate. You have your rental real estate. To save some money, you instead of having separate siloed LLCs or limited partnerships to hold the real estate, you put them all into one bucket. And then there's a lawsuit against one piece of real estate, an environmental claim, or somebody, we had a call once a few years ago. The tenant was drunk. She fell off of her balcony and sued the owner of the building for $20 million. I mean, this stuff happens all the time. So you want to understand the inside liability exposes the assets inside the structure. Outside liability is where the owner of the asset can be sued for a tort claim or some other third-party liability. It's very important for those on the call or on the webinar who own real estate and rent real estate to have a separate entity for each parcel of real estate, because if you lose one piece of property in a lawsuit, it's not going to spill over to the others. If you put it all into one bucket to save some money, you can lose it all. I've got a client, or had a client in New York, that had 100 taxi cabs, and he put 3 taxi cabs into each corporation because he wanted to silo the liability if one of his drivers, got into a serious accident and killed somebody, and he wouldn't wind up losing his entire business. That's all I want to say on the inside versus outside. And again, real estate is the most litigious asset that we have. It's not the kind of an asset you normally put into an asset protection trust or a foreign asset protection trust, because the court can always gain jurisdiction over the real estate itself. But it should be incorporated into your estate planning, and there are ways to incorporate it into your estate planning so you can move that asset off your balance sheet, and then if you're sued personally, those assets would not be exposed to your creditor claim.
Before we move on, Jeff, I want to go to a few different questions that have come in, a lot of which are interesting. Michael asks, do you consider using onshore or offshore PPLI with or without a trust for protection? I think there's a few nuanced answers to that. For those of you who don't know what PPLI is, that is an abbreviation for private placement life insurance, which is a hot topic in many circles. I think in professional circles, it's been a useful tool for 20 plus years now. In governmental circles, we have Senator Wyden, who leads Senate Finance, has launched an inquiry into this and has asked for the records from the top 10 PPLI providers in the United States. But as Michael mentioned in his question, PPLI can be onshore or it can be offshore. Offshore is usually used for more exotic assets, usually to have PPLI that involves closely held business interests or real estate or a few other things that are illiquid and not publicly traded. Only the offshore providers are willing to do that. The onshore providers typically are looking for publicly traded or otherwise forward-facing investment assets like private equity and hedge fund limited partner interests and things like that. But PPLI is useful. It's useful for a couple things, one of which is tax planning and the other which is asset protection. But I think, Jeff, you and I are using, when we encounter PPLI, we're using that in conjunction with trusts all the time.
Yes, I couldn't imagine doing a PPLI and not having it in trust. One of the problems with life insurance, even traditional life insurance, is when the exemption was raised to $12 million, a lot of people stopped putting their life insurance policies in ILETs because they didn't need the exemption to protect it from estate taxes. What they don't realize, unless you live in a state like Florida or Texas, the cash value inside the policy is exposed to liability claims, and the exemptions are very low. Like in California, where I practice, it's around $13,000. It's probably similar here in New York. So you wouldn't want to have a policy owned outside of a trust. The death benefit in California is exempt to the extent of the reasonable necessaries of the beneficiaries, which isn't very much. The rest of it's exposed. So yes, I haven't seen a single PPL case where that wasn't held in a trust, particularly a foreign trust. Most carriers want the policy in a foreign trust to avoid the regulatory challenges that you find when they're selling them to a U.S. person.
Furthermore, I want to cue in for 1 second, Michael and Richard, because in New York, we do have insurance law 3212, and we have analogous provisions of the debtor-creditor law, which are actually quite favorable to insurance cash value. In particular, a couple of these statutes provide that as long as the policy meets certain criteria, you actually can get robust protection for cash value of insurance policies. So New York is not the most unfriendly state, believe it or not, to the asset protection features of insurance. Insurance actually has some pretty good features to it. So Michael and Richard, I don't know if you have specific commentary on that, but it's actually it's counterintuitive to what you'd expect in New York.
I'll go first and then let Richard follow, because I know he wants to say something. My point was going to be that, yes, New York is a little bit more robust in their exemptions, but the federal exemptions are not very robust at all. So when you're choosing to file a bankruptcy petition, you have to carefully review the federal versus the state exemptions to determine which one is going to be more beneficial to the filer. And there's always a trade-off, because you may get a better exemption for the real estate homestead, but you won't get an exemption for cash. So you have to figure out and determine which is going to work out more beneficially for your client. I know you were about to say something, Richard.
No, I that's exactly the point I was going to make.
Oh.
It's just an analysis that has to be done. There are definitely pros and cons of state exemptions under the bankruptcy code, federal exemptions under the bankruptcy code, and the Article 52 of the Civil Practice Law and Rules, if you're just looking at protecting assets from a creditor judgment without a bankruptcy. So yes, you're right. It's column A, column B, and a lot of careful analysis, depending upon what a person's particular asset portfolio looks like.
Richard,
one
when
more
you've
thing,
represented creditors, question for Richard. When you represented creditors, Richard, and you saw a limited partnership or an LLC, and there was a charging order, how much did that weigh in your decision to pursue the claim against that debtor?
Yeah, I think anything that looks like it's going to be an easy path is going to make it easier to pursue the debtor, without a question of a doubt. As I said before, it's the low-hanging fruit. So collection attorneys typically work on a contingency basis, or many of them do, and some of them work on a more typical hourly basis. But either way, they're looking to collect assets as quickly as possible. And by the way, I should just point out, I think it's obvious, but it may not be obvious to all of our audience, that once a judgment is obtained, it's good for, depending on the state, 10 years or 20 years, and sometimes renewable. So oftentimes people forget about these judgments, and then all of a sudden, without notice, assets are hit. And that's why planning with experts is so important.
But one more point, sorry to interrupt. Matt, earlier on in the presentation, you mentioned all the offices, locations that Falcon Rappaport has. There is one more. We also have a New Jersey office. So anybody on the call, if they have New Jersey issues, we're able to handle New Jersey issues as well, having an office there for many, many years.
Well, that feeds into Bill's questions, which I was going to highlight. So Bill talks about the idea. First and foremost, he highlights a New Jersey statute that this is pretty standard across, I think, almost every, again, if you're not in a domestic asset protection trust jurisdiction, creditors can invade any trust, revocable or irrevocable, to the extent that the assets can be distributed to the settlor. That's pretty well established. Bill mentioned settlors, beneficiaries. I mean, to the extent the beneficiaries have creditors, if it's not discretionary to the extent that there are mandatory distributions, which you generally don't ever want to use unless you're doing it for tax planning for spouses and stuff, you generally never want to make the distributions in any trust mandatory. However, to the extent that you have mandatory distributions to beneficiaries, the beneficiaries' creditors can invade also. So that is the standard in non-domestic asset protection trust jurisdictions. And furthermore, right, spendthrift trusts, right? Bill's question is settlors in New Jersey from the creditor's ability to attach assets transferred to spendthrift trust. Spendthrift trusts are really about whether the beneficiaries' creditors can attach. The settlors' creditors are going to be able to attach based on fraudulent conveyance rules and based on the general debtor credit principles in the jurisdiction of choice. But I don't think there's anything in a non-domestic asset protection trust jurisdiction that would allow you, such as New Jersey, that would allow somebody to protect assets that a settlor funds in a spendthrift trust from the settlor's creditors if there's been a fraudulent conveyance or another similar finding. So you have to be careful with that. Janice also asked a question that I think is a bit of a layup for us. And Janice is asking, what would be the most significant benefit of dealing with a law firm as opposed to a financial advisor? That, I think, Jeff, you and I would both agree is a false dichotomy. Granted, a financial advisor is not privileged, but the law firm is working in conjunction with a financial advisor. These are not two opposing disciplines. I think, Jeff, you'd agree with that.
I would, and the attorney-client privilege is really important. If I'm representing a creditor and I want to blow up the head of the debtor and get that case settled quickly in my favor, I'm going to subpoena the records of everybody that debtor talked to, including his financial advisor, and I'll find out just how much of an intent to defraud there was based upon the information I get in discovery. So it's always best to rely upon the attorney-client privilege. Matt, just to put a finer point on what you just talked about, 95% of the lawyers who do estate planning trusts use the HEMS standard, health, education, and maintenance and support, for their distribution scheme. And under the HEMS standard, a creditor can force the trustee to make a distribution to that debtor beneficiary. So it's best to make the trust distributions fully discretionary, and that way a creditor can't force that to happen. So if you're doing HEMS standard trust, be aware you may be inadvertently exposing the beneficiaries to unnecessary creditor claims.
Very well said. So perhaps where we might, and we weren't quite able to get through everything on the slides, but where we might leave off is Ruthie, our colleague Ruthie, who Judge Kraft is in the Labor and Employment Group. And we call her Judge Kraft because she used to be a judge for the Department of Labor. So she's got a very good perspective on this. And the question here is, Fair Labor Standards Act proceedings. These are important, I think, for business owners, right? Asset protection in those types of things where you're bringing action under a federal statute, and the liability that may attach in the event that you're found in violation of perhaps labor laws or something else along those lines, right? Is there anything that can be done in those scenarios where all of a sudden, you know, liabilities under a federal statute, whether it's FLSA, it might even go as high as like civil RICO. Is there anything special? And I think, Jeff, this is really for you. Are there any special considerations there in terms of what happens when the liability arises from some sort of federal statute or federal cause of action?
Well, going back to Michael and Richard's earlier point about plan early so that you can prepare yourself. If you've planned early, if you've spun all the assets out of the employer into LLCs and leased and licensed the back, if you got the retained earnings out of the corporation, so you're not sitting with millions of dollars of retained earnings, Ruth. If you do the planning ahead of time, so you don't own the employer or the individual business owner does not own the assets at the time the claim arises, then you've got planning options. But if you try to do it once you get notice of the intent to bring those claims, you're really a dead duck, and you'll make matters worse trying to do the planning post facto.
So we have reached 1 p.m. Eastern, 10 a.m. on the West Coast. This is the allotted time that we have for today, but it does look like there may well be occasion for a part 2, because we couldn't even cover what we felt was like a pretty sparse outline that was just meant to go ahead and facilitate discussion. And it turns out we covered a lot of good material even before we got to some of our really good material. So we may well end up doing this as a part 2, but our contact information is here. It's on your slide. It's on the bottom right-hand side of the panel. And then if anybody wants to get the materials or wants to follow up with us, do feel free to get in touch with us at your convenience. And we'd be very happy to provide you with the materials. And if you want to set up a consultation to discuss this material with us, we're of course more than happy to do that as well. But we hope we were able to illustrate for you, even in the small taste, what the power is of the team we have behind us now, because now we cover this from angles that even other asset protection practitioners don't cover them from, because we now have the debtor creditor angles, we have the estate planning angles, the tax angles, and the team is very, very robust now, which we're really, really excited about as a law firm. So do feel free to get in touch with us if we can be of help to you. If you're a professional, we'd love to be of help to your clients. And any other information or assistance that you might require, do feel free to reach out to us with it. Also, special shout out to on our marketing team, Abby Winkler and Nick Miranda, who are going coast to coast. Abby from New York and Nick from California were instrumental in putting this together. We want to give them a public shout out for all their help in compiling the materials, marketing the presentation, and making this happen for everybody. So 3 cheers for Abby and Nick, and we're very happy you tuned in. Enjoy the rest of your day, and looking forward to next time on the FRB webinar platform. Take care, everybody.